Welcome to the Immigration Lawyers Podcast. I am the host, Attorney John Khosravi, and I practice U.S. immigration law exclusively. For more information about the program, please visit www.immigrationlawyerspodcast.com. Please note that this recording is informational only and does not constitute legal advice. Please consult with a licensed attorney for specific legal guidance that suits your case. Also, this recording is copyrighted and written permission is required for rebroadcasting. For more information about me, please visit www.jqqlaw.com. Hi everyone, welcome to episode 52 of the Immigration Lawyers Podcast, weekly episode covering August 31st through July 6th. As usual, it was a hectic week, not as much news, but some big events, but I'm going to cover a lot of practical stuff for legal practice today. But right off the bat, Trump's announcement about the RAISE Act. I warned about the RAISE Act a few months ago when Senator Khan and his buddy unleashed this bill to pretty much slash immigration, lawful immigration in half the United States. And now President Trump met with them, had a speech this week, and essentially added the employment portion of it, which is to create a points system. So obviously, if you're listening to this, you're not a big fan of the RAISE Act. It's going to cut out, brother and sister visa, children of green card holders, I think children in general, parents of U.S. citizens. That's very restrictive. It gets rid of the diversity visa lottery program. I think cuts down on asylees and refugees. And that was harsh in itself. But another thing they just added was this new employment-based points system. So they're going to rejigger the EB-1 through 5 categories, see what happens. Now, first of all, I don't think this is going to become law. There's just no way that's going to happen. There's going to be way too much pushback. This is probably an initial bargaining position they put into place so they could, start high and then see what else they can negotiate down. But having seen their success with healthcare and a bunch of other stuff they try to do, I don't see this going anywhere, even as a negotiating position. Sorry, we have this Alexa app in the house. I'm not sure if it came through in the audio, but it randomly just talks out of nowhere. And I'm pretty frustrated with that. I don't use it that much because I forget it's actually there. Alexa is the Amazon talking machine where you can ask questions from. It's not very bright either. When I ask it questions to do a specific question, sometimes it gives really good answers, but most of the time it just says I can't understand. Maybe I need to update the app or something like that. But it was one of those things you get just because it sounds cool. But I'd rather not have a device that's recording every word at home. But we have it anyways. I'll probably get rid of it. But going back to Trump and everything like that. So I don't think this is necessarily going to go anywhere, but it sets a tone and it shows how the other side on this debate is really coming at it, not just unlawful immigration, but lawful immigration. We could go into talking about what effects the population has for the success of a country, in particular the growth of a population, regardless if it's unskilled or skilled labor. America itself doesn't repopulate itself enough to sustain the population. So our influx of immigrants is actually one of our strong points in this country. And when you look at which countries have people coming here, it actually on a defense perspective, it's very helpful because the top minds are coming from the countries that could potentially be rivals to the U.S., whether it's Russia, China, Iran. All these countries, there's huge brain drain that comes here. So immigration is a win-win on every aspect. There is the welfare state and the issues with immigrants coming and then using the social safety net. That's a whole argument to be had, and I probably differ from a lot of other immigration attorneys on that. But the welfare state and the influx of populations that abuse it could be a problem. But in all, having people in the population growth is a positive, and I just don't agree with people who think that human population growth in the earth is a net bad thing. If we're smart about the growth, it's not an issue. For example, there's 1 billion people in India who are living, and it's okay. But then again, at the standard of living that they have. But then again, there's a couple 100 million people in the U.S., and we use and have so much consumption that we waste the equivalent of multiples of India with what we do. So, if I'm not necessarily worried about population growth and increased population, it's about how that population acts on a daily basis. And to a certain extent, if the standard of living rises, there's going to be consumption. But as it goes to, there's smarter ways of dealing with that. And we're going off tangents about geopolitics and all this kind of stuff. But all in all, the system about immigration that they want to fix up. I don't even think it's a broken system. I think actually could be fixed rather easily. But it's one of those emotional things that gets people, especially when there's downturns in the economy, which could happen at any time. Usually downturns in the economy happen in the fall. So if we have a September, October where some sort of economic crisis again, we could see this kind of stuff really popping up, especially in some other states, not California or New York, but even in California, there are parts where people are anti-immigrant. And so this sentiment could only rise because of the emotions of the economy. But with regards to the point system, what I was thinking about today at the gym was, well, before I went to the gym, someone had posted an article on CNN about the employment-based point system. Now, I haven't read all the bills, so I'm not sure how legitimate that article was, or the questionnaire they created where you can punch in what your background is, and it'll tell you if you have enough points to be part of it. Now, essentially, if you have a JD, you're going to be let in. You have JD and good English skills. That pushed me to like 33 points, which is over 30. I don't know how legitimate that is, but so that exists, and that could happen, and people get it. Now, there's a lot of people that have degrees overseas, and one thing that happens is there's a lot of degree mills that just pump out degrees. So immediately, there's the issue with this system where a lot of countries just get degrees just to get them. They hand them out like candy. So that's going to question the legitimacy of having that system based on just degrees, and not having employment lined up before they're coming based on degree and showing experience. But other than that, I thought, depending on how complicated this system will be, what's going to happen to our jobs? I've heard the Canadian system doesn't help the growth of immigration lawyers and sustaining business. But what happens for those that do employment-based business if all of a sudden, instead of EB-1s and EB-1Cs, extraordinary ability or multinational managers or national interest waivers and the PERM system and EB-5 immigrant investors, if these programs go away, what's going to happen to a large chunk of employment-based practices? Now, I don't think this is going to happen, so it's not a worry, but you got to keep it in mind. Who knows, like if people get really emotional and there's some sort of bargaining that goes on in Congress where, Democrats sell out immigration but try to get in on some other area and they try to negotiate, our practices could be hit pretty drastically, which always goes to the fact that always think about diversifying. If you're making a lot of money as an immigration lawyer, go buy a couple units, apartments, and rent those out or condos. Do something to diversify, because the legal field is finicky and it's political, so it could easily be manipulated to the detriment of a practice, especially immigration. That's so political. I would always recommend keep an eye out, and this is what I do every day while I'm working on as an immigration attorney. I'm always thinking, what can I do where I could diversify, and if my job ends tomorrow, what's going to happen? And this, I talked about this in the context of automation, where computer systems will be taking over large chunks of our jobs. What could you do to change that? How could you maybe invest to create that, or develop no creative avenues where machines can't do it, or it's so new it puts you ahead of the pack? So always, especially if you're a younger attorney, think about this and think about how could you do something differently to sustain yourself and thrive in the coming economy. Because one way or another, there's going to be changes. Now, if it's not the point system, it's automation. If it's not automation, it'll be something else. So just keep that in mind for business purposes. You got to take care of yourself first and foremost, and take care of your family. And if immigration law dries up to a certain extent, what are you going to do next? Are you going to go do more removal? Because removal is probably going to be good business. Or are you going to go move something else? I just can't see myself being any other type of attorney than an immigration attorney. None of them. If I fell into immigration law, if I hadn't accidentally fell into immigration law, I wouldn't be practicing law. I'd be something in real estate, buying, investing, or stocks, or something like that. But or sales, or media, or something like that. But the practice of law in any other field of immigration just doesn't make any sense for me personally. So moving on from that, some cool stuff and neat, interesting stuff happened. There was a civil suit, I believe from the ACLU, against the Department of State for their decision to stop people that are diversity visa green card lottery winners from being able to obtain a green card if they don't have that relative in the United States, as per President Trump's travel ban and the Supreme Court interpretation. So they filed suit saying that this can't happen, and they're stopping people from doing the interview because The ban is around 3 months. By the time the ban ends, it's late September. The visa numbers for a diversity visa are out. So it's a big issue. And it's interesting because I've had 2 or 3 emails in the last week or two from people that were diversity visa winners asking, could you file a lawsuit? Now, I don't do lawsuits. I don't know. I have to go somewhere else. I didn't get into a law with them in an email, but my question was, how do these people have standing from what I remember in law school? They're not U.S. people. They can't file suits. Do they have standing at all? I may be completely wrong because I can't remember my constitutional law correctly and my civil procedures, but I'm not sure they even have standing to file a lawsuit in the U.S. court. So it's a really unfortunate situation. To win the green card lottery, especially from some countries like Iran, which where from contacting me from, which is like people's dream in life is to win the green card lottery, and then for something like this not be able to get it. It's very sad, and it's very stressful for those people. Moving on, the Department of Defense issued a report about the MAVNI program, the program they have where they allow military people that are here, from foreign countries to get some sort of status based on being in the military. Now, I don't really touch these cases at all. I just refer them out to two attorneys, immigration attorneys I know that were in the military that know this program much better. But they issued a report saying there's been a security risk from allowing people these backgrounds to enter the Army. That's a pretty bad thing. I mean, they say it's a security risk. They've done the studies. I haven't really read the article fully, but it really paints a bad brush for people that are coming here and joining the military and doing all the good stuff for being a patriot American and having that shut off on them, especially people who are signed up and now are not going to get the benefits. So it's a very sad situation that's happening. There was a court case that happened this month, or pretty much last month. Kumar v. Kumar is the name. It's an interesting case. It's about affidavit of support. Now, basics are this. If you are doing a family-based petition and you sponsor a foreigner, you're stuck. You're on the hook for that, for the financial sponsorship of keeping their lifestyle at I think 125% of the poverty level. Now, that's a contract that the person has with the government, which means that there's no getting out of it. There's some exceptions. If the applicant dies, gets deported, they've worked for, 40 quarters, 8 years, they get U.S. citizenship, this, that, but there's no getting out of it. And that's something that people don't know, even though it's written in the contract in the form I-864. And I get calls on this once or twice a month saying they want to get out, they signed up, and I said, listen, you signed a dotted line, they got the green card, there's no getting out of it, there's nothing you can do. That's a binding contract. But in this case, a guy gets divorced from his wife, and long story short, the facts are pretty dismal. Like they treated each other. The petitioner treated the beneficiary pretty badly, but so they went to divorce court, and the petitioner in divorce proceedings said that the green card holder, the foreign spouse, didn't try to find a job to mitigate the damages, so they shouldn't be required to pay the affidavit support fee to keep them at that level. And the civil court, I don't know how they didn't read the thing. And this is one of those things that comes up is, and I say this all the time, unless you're an immigration attorney that practices a lot of immigration, you just don't know what's going on in immigration law. Because it's such a tricky field, and when you see a judge pass a rule, pass a case as they did here, which says, because the beneficiary didn't mitigate damages, try to find a job to pay for herself, the U.S. spouse, the petitioner, doesn't have to pay for the affidavit support sponsorship, even though it's binding and everything. So the applicant, the green card holder, appealed, and in California, the appeals court said this is like a new thing we're seeing, first time we're seeing this. So they said no, there's no duty to mitigate, which is I'm surprised they had to go on appeal. It should have been a quick thing. Obviously, I-864 is very clear on this, and there's precedent. It's just established law that there's no duty to mitigate. You're just bound by it. So that was an interesting court case that happened. And one thing is, the amount the spouse had to pay the wife for the affidavit support, it's not that much. How much is it? Like $12, $15, maybe $22,000 actually a year. The amount of attorney fees they paid extra to do this, it's amazing. Like, it was even worth it. Maybe in the long term it adds up. But I think one of the reasons why a case decision like this happened is because, the parties probably didn't have enough money to argue this properly. So the initial court couldn't get a good understanding of it. Because it would have cost a lot of money to do the research, especially because the family attorney probably tried to argue it themselves. and didn't get an immigration attorney involved because the immigration attorney would cost more money and they didn't have money. So all of a sudden, that initial court case has a bad outcome. Luckily, the appeals court caught it, but then they had to spend more money to get there. But the appeals court caught it and fixed the law as to what it is. Now, it is a little harsh for the affidavit of support that it's binding so much and you can't get out of it. I have somewhat understanding when I've seen petitioners are with a good heart marry a foreigner. Foreigner comes here and bails on him, and then the petitioner's on the hook. Now, it was bad judgment on their part. When I've seen these cases, it was very obvious to me like that spouse was going nowhere. But people fall in love, people are lonely, desperate, all that kind of stuff happens. They make these decisions. The fact that they're on the hook is it kind of sucks, but I think it's a good rule to have like this because a lot of times when these foreigners come here, they have no family, no connections, nothing. And if the petitioner lets them go, all of a sudden they're stranded here with no language and no skills and no way to support themselves. So there has to be that responsibility, especially because the responsibility of it goes back to the taxpayers and to the welfare state again. So if someone wants to petition someone else, they have to go on the hook, read the I-864, and do that. Now I have, and I'm making this website when I make this all available. I just haven't had the time, but I have a questionnaire and a letter I give when there's a joint sponsor that really breaks this stuff down. Because if you look at the Form I-864, the new one that came out last year, it has a part that says, has the attorney gone through this form with you? Which is ridiculous for an attorney to go with the joint sponsor who could be living somewhere across the world who doesn't even have time to do this, to sit there and go one by one with the questions. But I pretty much, all the major parts of the affidavit of support, I typed it up in a 1.5-page letter. It's really 1 page and 4 lines. And I sent it to them to read and sign off to say that they read that. Because they might not read the form, but at least they read that letter. And in this case, I have 2 ways of knowing for sure that I'm not on the hook. Because once they sign my letter, that tells them that they're on the hook for this. And second, they read the I-864. So I can wash my hands of any liability on that end. And if you want a copy of this, just email me, info@jqqlaw.com, info@jqqlaw.com. I'll be happy to share it. And I'm going to put it up on a special website along with some other goodies, my intakes and stuff like that pretty soon when I get a chance. But yeah, long story short, cover yourselves as immigration attorneys, and it's an interesting case. Just to clarify, and for you all remember, people are on the hook when they sign the I-864. USCIS last couple of months issued a bunch of new forms, including the EB-5 forms, the I-526, I-829, the I-921, I think. And recently they just issued something on their website which is really neat, which is their preferred way of putting these forms and the attachments for the EB-5 in order, which is very important because it's always a question of what is the proper order to put something. Even for marriage cases, I think, what is the proper order to put things in? And they spelled it out right there, which is really good, especially for people that haven't done EB-5. It's a way to learn it, because one thing I realized with a lot of business-based immigration cases like L1s and EB-5s, it's really hard to learn what to do because it's just a fluid thing and it's so big and complicated, and you got to really see how it's done. By them having a breakdown of what order it should be in, it helps educate people on how to do them, and that's a good thing. My goal in life as an immigration attorney, obviously, when you share this information, you're giving more people the ability to compete with you, but I don't really look at it like that. The most important thing is that people who are coming to this country don't have a bad attorney that does them wrong. I want them to come here, have the attorney do a good job, and really immigration attorneys are our colleagues, brothers in arms, really against the adjudicators, so you make sure they do the other stuff right. So anything I could do to make our side the good guys and do things right by the book, and education is part of that, I'm happy to do. Along with that, Ayla had this posting that was really interesting. They had spoken with USCIS about what they like and don't like when people send in forms. And here's a list of the stuff that stood out that I want to talk about. There's a couple of things in there that I read from other websites which I want to put to you guys to talk about as well. First of all, when you're doing a G28, again, this isn't in the Ayla forms, the first 2 things, but they came up on some forums, and I want to see your opinion. Always you can email me at info@jqqlaw.com. When I get your opinions, I'll share it on here. But when you're filling out a G28 or the beneficiary's information on I-130, I-45, do you write their full address, or address you kind of have to do, but phone number and email and stuff like that? There were some people in a form that said they never provide the phone number and email of the applicant. They put their own contact information in there. I've never done that. I always put the applicant's info. They never actually contact them, so it doesn't really matter in my opinion. I mean, they may contact them, but it seems like the appropriate thing if they ask for it. But a few people said that, no, we never provide that. So I'm interested, do you do that? What is the reason behind not doing that? Or have you had problems with not providing the phone number and that kind of contact info? Second of all is printing the G28 on blue paper. Now, a lot of the old timers know about this. It used to be required that Form G28 has to be printed on blue paper when you're sending it in. That hasn't been the case for a long time. Since I've been practicing since early 2010s, I haven't put it in blue. Now, when I worked at another firm, which was an old timer, I was doing it. He forced us to print it in blue, and I have a bunch of blue paper, but it's a hassle to put in the printer and all that kind of stuff. So I don't even bother. It's never been an issue. It might look better if you're looking through a file just to be able to identify the G28 quicker. I've had one or two cases out of 100 or 200 where they did not see the G28 and that was an issue. It's a rare thing. I think potentially would happen anyway if they had a color G28. But here are the tips Ayla had that was really interesting. First of all, when you're doing an attachment or addendum, you have to put the name, alien number, form type on the top of the letter, but also on the bottom, write what page it is and what page of it is. For example, if it's a one-page document, and I've never done that, I started doing this after reading this, is write 1 of 1, or if it's 3 pages, write 1 of 3, 2 of 3, 3 of 3. So they have some sort of context to know how many papers there are. If they get misaligned or this and that, they could fix that up. Also interesting, what they said is when you mail the envelope in and on the cover letter always do this anyways, but mark on their original submission, if it's the original submission, brief for appeal or RFE, write that on there plus the form type. So if you're mailing in an I-130, I-485 immediate relative adjustment, obviously in the cover letter you write what you're doing, what you're providing in the forms, but on the envelope it says where the mailing address is, like USCIS, Chicago, lockbox, blah, blah, blah. Maybe do a parentheses or something that says original submission, I-130, I-485, I-131. That's going to take a lot of space and the post office might get confused. I would probably just do the main ones, I-130, I-485. But list that in there. I guess it helps them better understand what's going on. And if it makes the case move up 1 day faster, that's 1 day faster for your clients. Now, they say don't use difficult to use staples. There's some hardcore staples that are really difficult to open. Don't use those. I personally have stopped using staples in all my petitions applications for many years now. I send it as a page, loose pages, because I put a binder clip on it, but I send it as loose paper because I remember going to some sort of USCIS thing, and you saw they just feed these, when they get the application, they feed it into a scanner. So if it has things that prevent them from doing that, it's going to create more work for them, which means when they open up the staples, they might throw them or get annoyed and not deal with it right. So I put a binder clip, let them feed it into the system, put it back on, and that's how I keep it. It's been good for now. I used to page number everything in there. I have a stamp that says, I would count how many papers are in there, stamp each page, and write the page number so they could see out of this 100-page packet where everything is in order. But that was way too time-consuming, and I got to the point where I'm not sure if that's necessary, so I stopped doing that. But they say you can do that, but just you can't staple. Just don't use hardcore staples. Also, always two-hole punch. I said this last podcast. Two-hole punch the top. It says if you do highlights, be careful because the color of the highlights could ruin a scan or a copy for them because they might be too dark. When I do highlights with yellow and I create copies, the yellow doesn't come through. It's like it has been highlighted. So that's what I do with. With regards to sticky tabs, they say, or some sort of dividers and stuff. Now, I stopped doing dividers a long time ago because I saw they throw those away. But if you're doing some sort of sticky tab to identify a certain area, put them at the bottom of the page, not on the side. I guess when they're feeding the scanner, it's at the bottom, it won't hurt, but it's at the side, it doesn't feed in there, so they tear those out. Creates more work for them, more problems. So that's something I'll definitely say keep in mind as a tip when filing any application or petition. A couple of more things. I had a case, a Chinese case, was an investment case. They want to transfer funds to the U.S. When they went to the bank to do it, they realized China changed their regulations apparently, making it more restrictive to send money overseas. It used to be, I don't know, $50,000 a person. If you want to do EB-5, you get 10 people, each of them doing $50,000 transfer to the U.S. is okay. Now they've restricted it where it has to be less than $10,000, and it can't be, I think, to the same account or something like that. It really messed up. This was in a complicated E2 I was about to do, and it just really messed the day up terribly. So that's something mindful. If you have Chinese clients sending money over, they're going to have to figure out a way to do that. The restrictions are getting worse from China. I wanted to give a shout out and thank you to Joseph L. He answered a question I had in my last podcast about reentry permits. So when you're doing an I-131 reentry permit, you don't have to pay the biometrics fee if it's a child under 14 or a person over 75. However, USCIS still requires them to come to a biometrics appointment and do the fingerprints, even though there's no fee. So be mindful of that. Even though you don't pay the fee, they still have to do that. So if you have someone over age of 79 who's stopping here to do an I-130 and leaving the country, not only do they have to be physically in the U.S. to file the I-130, they also need to stay in the U.S. for the biometrics appointment. Now, a little tip, if it's really urgent and you can prove it, once they get the receipt, you can go to the USCIS field office and beg them, please, 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 could you let us just do the biometrics appointment today without an appointment notice, because we have this special thing you have to do, or urgent reason or need that that requires us to leave the United States. And I've had success with that in the past, but they were good facts. I had one person that was a doctor for the UN traveling to pretty bad areas and stuff, and they said, listen, we got to go. We have to do some UN stuff. So it took them like an hour and a half. At first they said no, then we said, listen, come on, talk to the manager, this and that. Eventually gave in. So it is possible, but I wouldn't just willy-nilly do it and charge a fee because you're going to be there for a couple hours. Also, Rahul W., thank you for contacting me. It was great speaking with you. And Anna Y., as always, you're very kind with your information. Thank you so much for listening to the podcast. Finally, moving on, I think it's the last thing I'll talk about for this episode of the podcast, which is I was talking with another attorney about this issue. And an issue is this: returning emails and contacts. One big problem I've seen, it's just with people in general. I'm looking for a new house right now, and actually we closed the deal yesterday, but we contacted, it was a rental, getting a new apartment, and we contacted probably like 50 people, these agents and people who have the listing outside the house to say for rent, and we're good buyers, money's not an issue, credit, all that kind of stuff. We just want to move in somewhere quick. And out of the 50 people we called, probably like 4 of them returned our calls. Now, some of them took days to reply, and now we already bought a house and they just replied. Some of them, remember one guy we talked to when we were like, oh, we're here to see the house. He's like, could you come later? I don't feel like doing it right now. I'm just like, this guy's selling a house and this is his mindset. So you see that in other areas of business, but I mean, I got to say, lawyers shouldn't be like this. I see so much when I contact other attorneys that they just don't respond to an email. And this is just like bad etiquette and bad manners. It used to bother me more. Now I just don't care. I'm like, they're lost. They're not going to get to know me, frankly. But I see so much of attorneys never respond to emails, even from other attorneys. I can understand some annoying people are contacting them, but if an attorney sends another attorney and they have a signature line identifying their attorney, common courtesy is to at least reply, even with a 2-liner, say I'm busy, I don't want to talk to you, or something. I get a lot of emails every day, a lot of from students, a lot of from random people. A lot of people have cases that are like, I'm not going to do, or like they're annoying, or I don't want to, but I'll still reply. And it's really common courtesy. And this one person that was, a new attorney speaking with me is, they contacted a lot of attorneys to speak with to just get some guidance, and none of them responded. It's very disappointing. We got to have a helping hand. No matter how busy you are, you have to make time for other people. For example, like when I was renting places, when I did finally rent a place, I contacted the brokers who had shown me a place just so they know I'm not in the market, so they could think like, oh, okay, I have other applicants, they could help them. It really makes commerce better if we help each other and notify each other. For example, if you, and you all probably get this, is you have people emailing your office saying, I want a job, this and that, send your resume. 99% of the people don't respond to that. And I remember when I was in the job search, once out of 100, when someone would reply back or send me a letter back saying thank you for applying, it kind of sucked that I didn't get the job, but at the same time, I appreciated just letting me know on the air. So I really think we got to do better at responding. Every time a person sends me a resume, I'm not hiring, but I say reply, thank you, I'm not interested, not interested. They say like, I'm not looking for something at this time, I wish you the best, this and that. So it's really important to do that. But having said that, I wanted to share that I can't hold everyone in a bad light on this. There are problems that do happen. I think it's rare that it's like this, but because I think most people just don't bother replying to emails. But I had 2 cases, and I was telling the new attorney about this. One was when I got my new office, there was a phone line that came with it, and I thought the phone line contacts my cell phone, my internal phone, and if people leave messages, it goes there. But about 9 months go by, and all of a sudden they tell me, listen, we're changing our voicemail system. So if you don't want, we're going to delete all old voicemails. Please let me know. Check them if you want us that. I'm like, what do you mean? Don't they go to my cell phone? They said, no, we have a different voicemail system. So I'm like, oh no. I go back into the voicemail system. I have 150 messages. Most of them were for ads and people selling me stuff, but I had a couple of good EB-1 cases, a couple of good marriage cases that I lost. And I contacted them, I apologized, and I explained the situation, just say no, but they already had attorneys. But one of the calls that was really disappointing myself was it was a law student from the Loyola Law School, where I teach. Another one of the immigration attorneys, or immigration professors, had recommended a student contact me for help. And it was like 4 months had gone by, and they left me a message. I never returned their call. So that student probably thinks I'm an a-hole, excuse the language, and then the professor probably asked what happened when John responded, and he said no, and I don't know who the professor is because the student just said my professor at Loyola said contact you. So I look bad in front of the student and in front of one of my colleagues at Loyola, and I don't know who it is, and the student left a message in. I was putting it off to call. Frankly, I think I was being embarrassed about what happened, and eventually I lost the phone number and the phone line got deleted, so that went nowhere. So if you're listening, my apologies. So there are times when the person doesn't respond isn't being a bad person. Another one was, oh yeah, so it is very interesting. I get a call, 3 years ago, I was networking with attorneys, and I met a guy. We decided to have lunch. We set plans. Guy never showed up, disappeared, nothing happened. And I was like, damn, this guy's so rude. An attorney says lunch, can't just tell me he's not coming and stand me up, and I didn't like that. 3 years go by, you get a phone call, this is last week, and we're talking, there's a client that says, doing a marriage case isn't bad, this is my situation. And he says a name, and I'm like, well, that name sounds familiar. We talked for about 20 minutes. It was another attorney, so it was like on the phone with him, good guy. And at the end of it, all of a sudden I'm like, hey, did you work in this area? Did you do this, 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 and this? He's like, yeah. I'm like, dude, you remember we had that time we were supposed to have lunch? He's like, oh, yeah. And let me back it up a little bit during the conversation. What happened was, right at the time when we were supposed to have our lunch, this person had an awful, I can't say awful, but he had a dramatic life experience that happened that just shook up his life. And because of that, just having lunch with me was probably on the last thing on his mind to think about as big as the event that happened in his life. And I didn't bring it up during the phone call. It wasn't proper, but I fully understood. And any frustration I had at the time of being stood up, it kind of put in perspective. I'm like, oh, he probably should have at least contacted me, but the shift in his life was so dramatic, I can understand that he just forgot it. So it's not always a bad thing that people don't respond, but it's pretty consistent where I see just people in general, especially in our practice, don't respond, and that's appropriate. What gets me the most is when I contact a previous attorney on the case, ask for a file or something like that, or some information on the case, and they don't respond. That's just malpractice to me. So obviously, if you're listening to this podcast, you care enough about your practice and to think about and listen to this stuff. You're not like that, but that's just something to do. And if you don't want to answer, or it's like a student that's contacting you for a job or internship or something, just say it's better to say you're busy. Just let them know. Like for example, our clients, if they come to consultation and disappear, and we're like, what happened to them? If they just respond and say, we decided to go a different way, wouldn't that be great? Now, they'll probably be shy to do that because one, they'd be afraid the attorney's going to follow up and try to sell them again on it. And two, they're just shy about telling something like that. So I don't hold that against them, but it would make commerce so much better if we had that sort of transparency and we just communicated when we want to say no even. I know it's a hard thing to say no to people, but even that is helpful in the long run. So maybe it's not, who knows. Thank you so much for listening to this episode of the Immigration Lawyers Podcast, episode 52, August 31st, July 6th. I'm probably going to do an interview with an author this week about a very interesting new book. But I'll keep you posted on that. If you have any questions or comments, please email me at info@jqqlaw.com. Very happy to see the number of downloads constantly on the rise. So many new listeners. Please contact me. I'd be happy to speak with you. This is a podcast intended for immigration lawyers, but if not an immigration lawyer, that may be okay. So feel free to contact me. Thank you so much. I look forward to seeing you all next week. Bye-bye.